For reasons mentioned in the judgment, this court is of considered opinion that this case is not a fit case to invoke extraordinary jurisdiction of this court under section Article 227 of the Constitution of India to interfere with the impugned order. As such, this revision petition is dismissed.
It is your lordship. Lordship, I would like to mention item number 48, lordship, because in this case we have filed an IA, lordship. Can this case come on Monday with the IA, lordship? We have filed
Item number 48. On Learned heard Miss R.D. Mujumdar, the learned counsel for the applicant / appellant, who submits that the appellant has filed an interlocutory application in this appeal.
Number 2532 of 2026.
Bearing IA number 2532/2026. However,
Seal.
I within bracket C लिखिबो. However, same has not been placed along with this record. Hence, she prays for directing the registry to place the interlocutory application filed by the appellant along with this record on any other day. The prayer is allowed. Let this matter be listed on 4th. Monday is 3rd of August.
Beg please, your lordship. My lord, I pray for listing of an FAO new matter, lordship, for admission next week, lordship.
Next week, dear. 7th.
Please, lordship, I am going to mention item number 17, lordship, for a password for a bill.
Heard Mr. A. Deb. A Kakoti. Learned counsel for the. You are for the appellant. Learned counsel for the appellant, who prays for an adjournment. You have informed the other side.
The step was not taken, lordship. That's for the admission, lordship.
Item number 7.
17, lordship. 17.
17. Right. Okay. The prayer is allowed. Let this matter be listed after a week on a date to be fixed by registry.
May I beg to mention item number 27, my lord. I am on behalf of Mr. P.K. Authorised, the senior counsel, my lord. He is out of station, my lord. And that two recorded because they are also not.
Heard Mr. What is your name? A.K. Azad. A.K. Azad.
Lordship.
Learned counsel appearing on behalf of Mr. P.K. Roy Chaudhary. Learned counsel for the appellant, who prays for an adjournment. The prayer is allowed. Let this matter be listed after a week on a date to be fixed by registry.
Interim order may be continued.
The interim order shall continue till
All right.
Pray, please, your lordship. We have paid for listing of a new RFP mallet on 5th or 6th, my lord.
6th.
Oblige.
May I please? So I beg to mention item number 26. Lordship, in this case, Dr. BP Todi is appearing, lordship, is not keeping well, lordship.
Heard Mr. A. Nath, the learned counsel for the appellant, learned counsel for the applicant, who prays for an adjournment on the ground that the learned senior counsel for the applicant is indisposed. Considering the ground, the prayer is allowed. Let this matter be listed after 2 weeks.
Lordship, your lordship, I beg to mention the listing of a MFA case number 104/2023, lordship.
12th of August.
Lordship, can be date we give you now to 12th. Actually, on 12th we have matters in flow.
21st.
May I please, Lordship? Lordship, I beg to mention item number 56, Lordship. Lordship, we have received the copy and we will file wakalatnama and objection also in the IA. So sometime may be granted to us, Lordship.
You have informed the,
Yes, with the consent of the petitioner.
what is your name?
MJ Gogoi, I am for the
Heard
respondent.
Mr. M.J. Gogoi. M.J. Gogoi, learned counsel for the applicant,
No, Lordship.
learned counsel for the opposite party who prays for an adjournment on the ground that they have been recently engaged and would be filing their written objection in this case. Also, Ms. A.B. Kayastha, learned counsel for the applicant who does not oppose the prayer. Hence, the prayer is allowed. Let this matter be listed after 2 weeks on a date to be fixed by registry.
Obliged, Lord.
May I please, your lordship? I beg to mention listing of 3 MFAs and orders for notifications.
Yes.
May it please, your lordship, I beg to mention item number 41. Lordship, in this matter, the name of the respondent has not been reflected in the cause list. Lordship, kindly adjourn the matter for 2 weeks.
Heard Ms. D. Goswami. Have you informed the,
No, lordship, the name of the respondent has not been reflected in the cause list.
oh, heard Ms. D. Goswami, learned counsel for the review petitioner who prays for an adjournment on the ground of the personal difficulty of the conducting counsel for the petitioner. The prayer is allowed. Let this matter be listed after 2 weeks on a date to be fixed by registry.
Obliged, lordship.
Pray for listing of an MSc appeal, madam. Last listed more than 3 years back. Any confirmation?
Orders called
Orders, madam. Orders. No further.
12th August.
Speak, madam.
May I please, your lordship? Lordship, I would like to beg to mention item number 20. Kindly adjourn the matter for the day.
Why?
Lordship, my senior is not available today due to
Heard
personal reasons.
Ms. D. Hajorika, the learned counsel for the appellant who prays for an adjournment due to personal difficulty of the conducting counsel for the appellant. The prayer is allowed. Let this matter be listed after a week on a date to be fixed by the 21st of August.
May it please, your lordship, I beg to mention for listing of FAO on 4th of August for withdrawal of the case.
Okay. Okay, allowed.
My lord, on the last occasion, what I have argued, my lord, I have given a summary of those, that argument.
You have already argued.
Yes, that summary of that argument, my lord,
Okay.
I have given in detail. The only point was that, my lord, if your lordship remembers, primarily I was arguing that as per as the mandate of D.K. Bosu, my lord, that their arrest memo has to be attested by 2 persons, out of which one either has to be a relative or a person from the locality where the arrest is made. That was the direction given in paragraph 35, subpara 2 of D.K. Bosu, and para 37 of D.K. Bosu says that these requirements referred above flow from article 21 and 22, 1 of the Constitution. And in my case, my lord, the 2 witnesses, one is from
I remember your submission,
Rongia and other.
but his objection was you have not pleaded.
Then I have filed a additional affidavit with the liberty of this court. Last occasion, this court gave me liberty. I filed an additional affidavit that very day, and they have filed a reply to that also.
It is on record.
The reply has also.
Both are recommended. Yes, what is yours?
Your lordship, let me senior start then with regards to.
The reply which I have seen from their affidavit, the DRI is of the opinion that 2 witnesses would suffice. My lord will kindly take their affidavit, the reply affidavit, which was filed on 27/7/26.
এফিডেভিট করতেছে।
27 তারিখ হবে।
Your affidavit is there.
Even there is also there, my lord.
Ours is just after, Your Worship. Filed on 27th.
Let me see DNS. DNS.
Yes, reply.
My lord, may kindly come to paragraph 5 of their reply.
Yes.
They say that it is not possible to have our family members. I can understand that. Then, my lord, they say that section 36 simply says respectable member of the locality wherein the arrest is made and does not mandate that the said person should be resident of the locality where arrest is made. Now, my lord, this is a super philosophical line I fail to understand, my lord. The mandate is that, my lord, they are from the locality. And admittedly, my lord, these two persons are not from the locality.
No, they say that they should not be resident of locality.
But may not be show something that they are from that locality. Their document, my lord, interestingly, my lord, your lordship would appreciate there is no 161 statement of these two persons. From their document, that is page number 61 of the bail petition.
No, their plea is that they were found in that locality when the arrest was made.
My lord, how? Because, my lord, how do we come to know? Because we will go by the records of the case, my lord. Kindly come to page 61 of the bail application, my lord. Page 61.
No, I have gone through.
Yes.
Their submission is that residency is not a essential condition under section 36. That is their submission.
Now, my lord, if I read subject to what this court feels, my lord, if I read the plain provision of section 36, the way it appears in the text.
That which means that they must be local.
They must be from the locality, my lord. It is not that any person who is a passenger by. My lord, will see the language.
Okay.
My lord, is there at page 36?
Yes. Yes.
Section 36B 1. Attested by at least one witness who is a member of the family of the person arrested or a respectable member of the locality where the arrest is made. He has to be a member of that locality, not a passenger. Well, this was in fact added after the D.K. Basu versus State of West Bengal judgment. This was not there in the original text of the, my lord, when in the original CRPC. It is only by means of an amendment in the year 2008, this provision was incorporated in CRPC as section 41 capital B. Now, once BNS came into force, this provision was made under 36. The basic purpose is that so that it lends some credence that a member of the locality, he may have some establishment in the locality. Otherwise, my lord, they will have pocket witnesses. Any person they will bring from Delhi, Bombay, and they'll say, oh, that day he was there. He was loitering there. And so we made him. That's not the mandate of the law, my lord.
Suppose the arrest is made where there is at a place where there are no residents, no inhabitants. How 36 would be compliant with?
Now, my lord.
Arrest is made in a jungle.
Now, my lord, if
at an open space where there are no inhabitants. how this 36(1)(b) would be followed.
Absolutely. My lord. Now, my lord, there was a case, my lord, since it has fallen from your lordship, I'll just answer it. There was a case where an interception was done in Kajol. Kajol is that Himachal Pradesh in the midnight, where there was no resident around. There is a judgment in that regard. There was no resident around. Then, my lord, the Supreme Court says that the prosecution need to make an attempt. And thereafter, if they cannot, then it will not go against them. Because that is an exceptional circumstance. Exception, then circumstances are different. Here is a case where morning 9 a.m., according to them, in Khanapara flyover, one of the most busiest place in the vicinity of Gauhati city,
So your submission is in this case, there was no attempt was made to search a
and which is
person.
evident from their,
Okay.
because there are hospitals, my lord, there are vehicle showrooms, there are hotels, there are n number of business establishment in and around Khanapara flyover, my lord.
Yes.
Leave apart those high-rises residential buildings. Nobody, these two gentlemen, one from Rongia suddenly appears and one from Udal Bakra.
Okay. Anything else?
This was one part, my lord, because on the last occasion only that whether there was anything in the record, contemporaneous record.
How many days you are behind the bars
As
on today?
As on today, it is 1 year, 5 months, 13 days, I suppose, my lord. 1 year, I'll give the exact 1 year, 5 months, 13 days. And moreover, my lord, here again, they were produced after more than 24 hours, which is also evident from their record.
Okay.
Which is evident from their record on the last occasion I have indicated, even in my, because 9 a.m. they have
You have
intercepted.
submitted a written gist of your submission.
Yes, my lord. That along with the page numbers where those record appears.
Yes.
Now, if they can show that these two gentlemen are from that locality.
Yes, Mr. Bora.
Your Lordship, on last occasion, of course, I placed this judgment of which fell from your Lordship because on a very similar circumstances, wherein in that case also they had alleged that they were detained or arrested at 1 a.m. and produced before the magistrate after 24 hours. But here, I will not argue on that particular aspect. The only point that needs to be argued, because only on last occasion was the compliance of Section 36 and nothing else, Your Lordship. That was actually what fell from your Lordship, and that's why leave was granted to them to file an additional affidavit and bring on record their submission with regards to non-compliance of Section 36. Now, in reply to that additional affidavit, we have filed a reply. Therein, in our reply itself, we have mentioned at paragraph number 5, most importantly, from the last line onwards, further, the Section 36 simply states about a respectable member of the locality where the arrest is made and does not mandate that the said person should be a resident of the locality wherein arrest is made. Moreover, both the petitioners and accused persons were intercepted and apprehended near Khanapara flyover, which is a commercial place having bus stop, taxi stand, etc., with shops and other business establishment with no residential houses near it. So it is not possible to get a resident individual from the locality of Khanapara. Further, none of the persons working in the business establishments agrees to cooperate with the officials, especially after knowing that it will be a NDPS case. Therefore, since we could actually only these two persons, so moreover, since it's a bus and taxi stand, majority of the people found therein are travelers or tourists who never came even close to the officials, and so after lots of persuasion, the DRI officials are compelled to take any available person, Your Lordship, who willingly agrees to be a witness in the entire interrogation. So this is we could
So according to you, what is meant by respectable member of the locality?
So as per my understanding goes, Your Lordship, he did not be a resident of that locality.
What he has to be.
But he has to be present in that particular locality at the time of arrest. He should. So that is my humble submission, Your Lordship. His residence is not required, Your Lordship. The mandatory.
Mr. Ambish, I'll dispose of this today itself, dictate it in chamber. I'll have to go through your written arguments.
Now, my lord, whatever my last one line rebuttal, my lord, that they tried to bring other members, right? Whether that is there in the record, my lord. Whether any 161 statement has been recorded, my lord.
Okay, I'll consider.
Well, these are the things, my lord, why they do not record 161 statement, because they play safe so that they can manipulate anything during trial. There is no previous statement to contradict them.
Okay.
So at times it becomes
I'll
counterproductive.
consider your submission and dictate the order in chamber today itself. By evening, you will get your.
And that will be, and that 24 hours, that submission will also be taken
I'll
into.
consider everything.
Because I have given the para numbers, and I've particularly shown that for 45 long hours, there was no investigation. Meaning thereby that what I am submitting in affidavit, which has not been contradicted by them, that they were arrested at 1 AM in the midnight, is more, my lord, akin with the facts of the case, my lord. And there is no contradiction from them. That was brought on record by means of an affidavit. There was no contradiction from them. They did not contradict it.
I remember your submission.
My lord, I am deeply obliged.
Your lordship, in this regard, I have submitted one judgment, MP Mariappa. Perhaps it is on record. If it is not there, your lordship, I am again pleading.
Okay.
Because Mariappa is a different platitude altogether. Last time your lordship have also seen, because there was some summon and all these things.
So this
Here,
was
my
also-
lord.
This was also same summons were issued.
Okay, wait for the order.
Order, item 22.
May it please your lordship, in this matter, as per office note dated 13/7/2026, service report is awaited, my lord. TCR has been received.
Third Miss
S.T. Murtaja.
S.E. Murtaza, the learned counsel for the appellant. When have you taken steps? 2020, you have to take fresh steps. On perusal of the office note dated 13/7/2026, it appears that service report in respect of notice issued to respondent is awaited. The appellant is directed to take fresh steps for issuance of notice to the respondent by speed post as well as by usual mode within 7 days from the date of this order, returnable on 2nd of September.
Lies.
Item 23, 24, and 25.
May please loss, my lord, I mentioned item 24 and 25, my lord. In fact, I am not aware of about 23. And 24 and 25 I mentioned, my lord, because on behalf of the respondent number ones in respective cases, the last year's red earner has been. And
24 so. Yes, who is for the appellant?
appellant Mr. K.K. Patra, my lord. And
Insurance company.
or respond. In fact, I mentioned the case because for fixing the date of early hearing, my lord.
Okay.
These women lost their husband.
These appeals are ready for hearing.
Yes. So if you lost, you can be pleased to fix the matter in the second week or third week of August, my lord. My learned friend is also for one of the respondents. Last week of August.
Item number 23, Lekibo. None has appeared for the appellant on call. It appears that notice issued to respondent number 7 has not yet. No, service report in respect of notice issued to respondent number 7 has not yet received. Has returned with a report that addressee could not be traced. In view of the above, anybody is appearing for respondent number 7? No, appearing for respondent in 23.
23, I am appearing for respondent 5.
Mr. P. Hajorika, Learned Counsel, appear for respondent number 5, as well as Mr. A. Bhattacharjee appears for respondent number 4. The Learned Counsel for the appellant is directed to take fresh steps after ascertaining the proper address of respondent number 7 for issuance of notice upon him by speed post as well as by usual mode within 7 days from the date of this order, returnable on 2nd of September. In item number 24 and 25,
There are two different. It will be segregated item number 23.
item number 24, 25 separate,
They are similar. These are-
24 and 25 separate order, 23 Beleg order. None has appeared for the appellant on call. Mr. M. H. Rajbar Bhuya appears for respondent number 1, 2. Respondent slash claimant. Whereas Mr. P. Hajorika
They are looking for number three.
appears for respondent number 3 in MAC appeal number 662 and respondent number 6 in MAC appeal number 199. Mr. A. Bhattacharjee appears for respondent number 2 in MAC appeal number 662 and respondent number 5 in MAC appeal number 199. This appeal is ready for hearing, hence let's list these appeals for hearing on date Tadyo. When you want. Last week, Amar Mate.
Maybe on 25th, my lord. Hearing date.
Okay, 25th August. Same order.
28. Much obliged.
Who is for the appellant?
For the respondent, Lordship.
What happened in mediation?
Mediation, it was failed, Lordship. It failed, the mediation is failed. As we are on the day of mediation, the petitioner has assaulted the respondent, Lordship. Basically assaulted the petitioner
During mediation.
during mediation, Lordship. That was reported to the mediator also. And FI was also been lodged with the police station, but they did not
2025 has dismissed the prayer for 26/6/2025 passed in IS civil number 1833/2025 has dismissed the prayer for condonation of delay, and as such he submits that since in this case also similar pleas are taken by the applicant, the prayer for condonation of delay should be dismissed, should be rejected. Stop. Mr. K. Bhattacharya, the learned counsel for the appellant and learned counsel for the respondent number 2 / State of Assam has submitted that since public money is involved, it would be proper that the court goes into the merit of the appeal and consider the appeal on merit as the as the compensation and has been enhanced from rupees 6 lakhs to rupees 15 lakhs per bigha.
9 lakhs.
9 lakhs.
6 to
15 lakhs.
Lordship, per bigha, it was 9,94,600, and his land was 3 katha, 4 lesser, therefore proportionate, his compensation was 6 lakhs. 6 lakh, 36,160 per first para, Lordship. It is mentioned in first para of our IA.
From 9 lakhs to 15 lakhs.
Mm.
From 9 lakh to
9 lakh 94,600 per bigha to 15 lakhs per bigha. Pair number 1 of the IA lots of condonation petition.
okay. Got 6 lakhs जो लिखी से 9,94,600 per bigha. I have considered the submissions made by learned counsel for both sides.
Railway is a public utility subsidy. This for the public utility.
And Lordship, in Uttar Kumar case also, Lordship,
Some cases are there on that.
Learned counsel for the applicant for the learned counsel for respondent number 2 has also submitted that this court may take into consideration the fact that the appellant and that the applicant number 2, namely railway, is a public utility service, and as such a liberal approach should be taken. I have considered the submissions made by learned counsel for both sides and have gone through the
My lord, some case laws, my lord, these are already referred in the earlier judgment, my lord,
gone
all
through
these case laws.
gone through
When the government is a party, what treatment is to be made? There
got,
cannot be any differentiation in absence of satisfactory explanation. There cannot be any different footing for the government department.
let me dictate. I have
My- my- all these cases are referred in the earlier judgment.
case below learned counsel for the respondent has also cited following rulings in support of his submission. Respondent opposite party number 1. This on perusal of the instant interlocutory application, it appears that the applicant has only pleaded in paragraph number 5 of the instant interlocutory application that the concerned authorities responsible for granting approval for preferring an appeal against the impugned judgment took some time, and in the process the prescribed period of limitation lapsed. However, nothing has been indicated in the in instant interlocutory application as to when the process of obtaining approval for grant of approval for preferring appeal was initiated by the railways, and when it culminated. The only date mentioned in this interlocutory application is that of 25/2025, when the appeal has been filed in this. In this case, after lapse of more than 300 days beyond the prescribed period of limitation. This court is of considered opinion that though a justice-oriented and a liberal approach has to be taken while dealing with an application under Section 5 of the Limitation Act, and some more liberal approach has to be taken in case the litigant is the government or government department. However, there is a point beyond which even the courts cannot help a litigant. Where the negligence and delay in preferring the appeal within the prescribed period of limitation is apparent on the record itself. In the instant case, no reason except stating that delay has been caused due to obtaining administrative approval for preferring appeal in this case. It also appears that in the connected interlocutory application arising out of a connected land reference case, that is LA reference case number 1 of 2015. Similar stand was taken by the applicant, and delay has not been condoned by a coordinate bench of this court.
SLP also was
In-
dismissed.
Where is the SLP order?
SLP order I have submitted. With my additional application.
It also appears that the railways preferred
Additional application.
a special leave petition before the apex court. However, same was also rejected by the apex court.
Order is 8/12/2025.
By order dated 8/12/2025 in SLP Civil bearing diary number 62950/2025. In view of the discussions made in the foregoing paragraphs, this court is of considered opinion that the applicant has failed to show that it was prevented by sufficient cause in preferring the connected appeal within the prescribed period of limitation. As such, this interlocutory application is dismissed.
Item 34.
Correct.
May I please the lordship? As per office last order, lordship. Service is not served, lordship. 726.
Heard Mr. S.I. Talukdar, the learned counsel for the applicants. Also heard Mr. What is your name?
RK Singh, lordship, for respondent number 1 and 2.
R.K. Singh appearing for respondent number 1 and
2.
2.
We'll file
Oh.
5 on this case, so with some time, break for time.
On perusal of the office note dated 27/7/26, it appears that service report in respect of notice issued to respondent number 3 has not been received. The registry is directed to place the postal track consignment report of notice issued to respondent number 3 by speed post before this court on the next date fix. List this matter again. 21st August.
35.
My lord, the IA is for condonation of delay of 280 days in preparing the first appeal. So the delay has been explained at paragraph 3, 7, and 8. Mainly because of ill health and also financial constraints. Otherwise, also, my lord, they on merit, the petitioner.
Where are the reasons?
Paragraph 3. Paragraph 3, 7, and 8.
Yes, Mr. Dhar, you are opposing.
Find my affidavit in opposition of it. But she will find the.
What is enteric fever?
Yes. Enteric fever. And the certificate was of 25th of August 2024. And the judgment was passed on 30th of.
So he fell
September.
ill before the judgment was delivered.
Let me finish.
Let
Let me finish.
30.
It was passed on 30th of September 2024. Certified copy was applied soon after the judgment. And it was delivered on 21st of November 2024. So since November 21st of November 2024 till 6th of November 2025, when the present appeal has been filed, there is no explanation of each day's delay, why the delay has caused. And this medical certificates, your lordship will find in affidavit, he has shown the affidavit as his age is 51 years. Page 10, age is 51 years. And in the medical certificates appended with this, his age is in 2024, his age was 54 years. So these medical certificates are very doubtful certificates. And moreover, with regard to financial inabilities, he is a class 2 contractor. And he could not file the second appeal because of financial constraints is unbelievable, my lord. That is my, in fact, my objection, and each day's delay and has not been explained why this delay has occurred. Because the certified copy was delivered on 21st of November 2024.
Well, what was the date of the,
Date of judgment,
yes,
39 to
39/2024. He applied for certified copy on 29th October 2024, and which was delivered on 21st of November 2024. And this appeal has been filed on 6th of November 2025.
okay, what is the explanation for 6 November, 30, 21/11/2024 to 6/11/2025?
This is a financial constraint, my lord. He was out of work, though he was registered as a class 2 contractor, but he was not working on those periods, and he was suffering from illness, and he has to pay for his medical bills and all other things. And since he was not working, so he is suffering from financial constraints. This is the explanation for that period. And this is a bona fide inability to approach this honorable court. And he has a strong strong case on the merits also.
Heard
Also,
Mr. Oloskar, the learned counsel for the applicant. Also heard Mr. Adhar, the learned counsel for
All the response.
all the opposite parties. This interlocutory application under Section 5 of the Limitation Act has been filed by the applicant Shimul Das for condoning the delay of 280 days when preferring the connected appeal within the prescribed period of limitation. By the said appeal, the applicant has impugned the judgment and decree dated 30/9/2024 passed by the Court of Learned Civil Judge, Senior Division, Karimganj, in money suit number 12/2019. The learned counsel for the applicant has submitted that the applicant has mentioned the reasons for delay in preferring the connected appeal in paragraph number 3, 4,
up to 8 million.
3 to 8 of the instant application. He submits that the reasons shown by the applicant in the instant interlocutory application were beyond his control and may be considered as sufficient cause which prevented him from preferring the appeal within the prescribed period of limitation. On the other hand, Mr. A. Dahar has opposed the condonation of delay of 280 days in preferring the connected appeal by the applicant. He submits that the medical certificate submitted by the applicant in support of his contention that he was ill pertains to even before delivery of the impugned judgment. He further submits that though the certified copy of the impugned judgment was received by the applicant on 21/11/2024, however, no day-to-day delay has been explained as to why for next 280 days the appeal could not be preferred within the prescribed period of limitation. He further submits that since the applicant was a class 2 contractor, the plea that he could not prefer the appeal due to financial reasons is not believable. I have considered the submissions made by learned counsel for both sides and have gone through the materials available on record. It appears that the applicant had suffered a head injury and fracture of bone in the month of August 2024 and also suffered from vertigo and enteric fever. Stop. While considering an application, I have also taken into account the grounds stated in the memo of appeal by the applicant. Stop. While considering an application for condonation of delay, a justice-oriented approach has to be taken. Though in the instant case, day-to-day delay has not been explained by the applicant. However, considering the grounds stated by him in his interlocutory application for the delay caused in preferring the connected appeal, this court is of considered opinion that under the facts and circumstances of this case, same may be regarded as sufficient cause which prevented the applicant in preferring the connected appeal within the prescribed period of limitation. As such, the period of 280 days in preferring the connected appeal is hereby condoned. Delay of 280 days in preferring the connected appeal is hereby condoned. And this interlocutory application is allowed. Registry to register the connected regular first appeal and list the same after a week on a date to be fixed by it.
Right. Okay. I
think 46.
As per office to notice upon respondent number 2, written answer,
Since the appeal is against the quantum lordship, name of the respondent number 2 may be strike out.
Who is the respondent number 2?
Owner lordship.
Who is appearing for 1? Heard Mr. K.K. Bhatto, the learned counsel for the appellant. This, on perusal of the office note dated 29/7/2026, it appears that the notice issued to respondent number 2 has returned without service. Learned counsel for the appellant, the insurance company, submits that since the appellant is basically aggrieved with the quantum of compensation awarded to the claimant, the presence of respondent number 2 may not be necessary for consideration of the instant appeal. Hence, he prays for striking out the name of the respondent number 2. Prayer is allowed. The records of the concern record of the concern is the employee's compensation case have been received. Hence, this matter is ready for hearing. Accordingly, list this appeal for hearing after 4 weeks.
Was issued for consideration of the prayer for station appeal is against a money decree, madam.
Money decree.
Money decree of about 20 lakhs, madam. Out of that, madam, around 6 lakhs and odd was already paid to them, because for that matter a check was issued, and since the check got dishonored,
Today the matter is for
consideration of stay.
stay.
My lord. Now, in fact,
They have acknowledged that receipt of that 6 lakhs.
yes, ma'am. No, they are not. That has to be adjudicated, my lord.
Whether they have received 6 lakhs.
No, they have received. Lordship, may just have a look at page 90.
No, whether they are acknowledged,
They are not
accepting.
acknowledging.
They are not accepting.
That has to be adjudicated, my lord, before some put in the appeal.
Whether 6 lakhs have been paid or not.
Yes. In fact, my lord,
And nothing.
I'm just indicating for that amount a check was issued, check got dishonored. They filed a application under the Negotiable Instruments Act. In that proceeding, my lord, I pursuant to a direction possibly, I issued a fresh check and they have received that amount. And the finding of the court below is that whether that amount which they have received is in respect of this or not, there is no clarity. Otherwise, they have received that amount. For the remaining amount of about 13 lakhs, my lord, we filed an application before the executing court. They filed an application for execution also for an payment of the decretal amount on installment. That has been rejected on the ground that they have not consented, because the provision says after the judgment is passed, they have to give consent for that.
For installments.
Yes. Now, I am praying before this honorable court, my lord, that out of the remaining amount of 13 lakhs, Lordship will kindly stay the proceeding, will make a payment of 50 lakhs. And my instruction is that, my lord, 50 lakhs they will pay within 15 days.
Out of 13 lakhs?
50%. 50% will pay within 15 days, and the remaining 50% also we want to pay within 6 months if your lordship so directs, madam.
Then appeal will become infructuous.
Yes, we want to
So
pay.
you are ready to pay?
Yes, pardon.
Yes.
Yes, you are ready. Appeal will not will become infructuous, madam. That remaining 6
That
lakhs.
has to be
Yes,
adjudicated.
that your lordship will adjudicate.
Heard Mr. D. Mujumdar in IA. Heard Mr. D. Mujumdar. Learned Senior Counsel assisted by Mr. G.R. Datta, the learned counsel for the applicant. Also are Mr.
W Hawk, Lordship.
W. Hawk, appearing for
Sole respondent.
sole respondent. This application under Order 41 Rule 5 of the Code of Civil Procedure has been filed by the applicant in connection with RFA number 26/2026, praying for stay of execution of the impugned judgment and order dated 8/12/2025, passed in title suit number, title suit or money suit?
It's been registered as a title suit, actually.
Title suit number 3/2019 by the Court of Learned Civil Judge Senior Division, Lakhimpur, North Lakhimpur, whereby the present applicant was directed to pay an amount of rupees, how much? 30 lakhs?
20, my lord, page 37, Lordship, just have a look.
20 lakhs
20.
to the present respondent,
There is also an interest, Lordship.
along with interest at the rate of
Lucky in doing that.
how much?
10%.
10%.
10% per annum.
Per annum.
Learned Senior Counsel for the applicant submits that out of the said amount of 20 lakhs, the applicant has already paid rupees 7 lakhs,
6 lakh 70,000, my lord.
6,70,000,
And PW1 admitted also that he has received this amount, in spite of that.
and receipt
It's
and
citizen.
and the said amount has been received, has also been received by the decree holder. Stop.
It is to be
He,
entered.
he further submits that, he fairly submits that the question which may have to be considered in the connected appeal is as to whether the payment of 6,70,000 made by the applicant to the respondent side is in connection with the decretal amount or it relates to some other payment. He, however, submits that the applicant is agreeable to pay 50% of 13 lakhs.
My lord.
50% of 13
13
lakhs.
lakhs, 30,000, Lordship, specifically.
13 lakhs 30,000 as a condition for grant of stay of execution of the impugned judgment. He also submits that the applicant is further agreeable to pay the remaining 50% of the said amount within next six months, within the period of next 6 months. You don't have objection. Once
6 months.
considering the submissions made by learned counsel for the learned senior counsel for the applicant, learned counsel for the respondent raises no objection regarding grant of stay of the execution of the impugned judgment. And accordingly, in view of the submissions made by learned counsel for the applicant as discussed in the foregoing paragraphs, this interlocutory application is allowed. Any execution case is pending.
Yes, my lord.
Accordingly, the execution of the impugned judgment and award in execution case number
2 of 2026.
2 of 2026,
In the court of
pending before the Court of Learned
Civil Judge Senior Division.
Civil
Lucknow.
Judge Senior Division, Lakhimpur,
My lord.
shall remain stayed, subject to payment of subject to payment of a sum of rupees, how much it comes?
6 lakhs, 65,000. 6 lakhs, 65,000.
Subject to payment of rupees 6,65,000 to the respondent within a period of 4 weeks.
So let me deposit in the executing court, my lord. Otherwise, there may be again controversy. He will not come to receive. There will be
Within a
delay.
period of 4 weeks before the executing court.
My lord.
The applicant may also deposit the remaining sum before the executing court
My lord.
within
6 months.
6 months from the date of this order. With above observation, this interlocutory application is disposed of. Appeal is ready for hearing.
The records are yet to be received possibly.
Records I say.
Records received, my lord. Lordship may proceed for hearing.
Okay. Heard Mr. Same Dikibo. This appeal is ready for hearing. List this matter for hearing after 4 weeks on a date to be fixed by registry.
Item 38.
Lordship, this appeal was already admitted. My impugn order dated 21/2/2026. The learned trial court granted injunction in favor of the respondent in the entire B schedule land. Interestingly, B schedule land did not contain any boundary. My submission before this honorable court is that subsequently we have filed a IA. In the IA, we brought that in the meantime they filed a petition for amendment of the boundary. So therefore, the order passed by the landed trial court is not sustainable. Because the landed trial court cannot pass the order in the entire property. And therefore, let the matter be let the order be set aside and let the matter be again presented to the landed trial court, sent to the landed trial court for re-hearing of the matter.
Now, why it has come in orders column today?
At the side, they actually on the last occasion they filed caveat, they are here.
We'll fix it for admission hearing next week.
Short date may be given.
Mm.
In fact, the injunction order does not stay. In the slide.
Oh, let it come in proper column,
Lordship.
admission hearing column next week.
Lordship.
Heard Mr. B.K. Bhagawati, learned counsel for the. Oh, it was admitted.
He is already admitted, Lordship.
Then for hearing next week.
Yes.
Also heard Mr. B.K. Jain, learned counsel for the respondent. How many respondents are there?
Only one, sole
Sole respondent. This matter is ready for hearing. Accordingly, list it for final hearing in the next week. 4th of August.
May I please, your lordship? Your lordship, kindly the matter may be taken up after some time, lordship.
No, my
The
lord,
engaged counsel is on
we
leg.
have filed an affidavit in opposition. That has not been tagged in the record. So, my lord, any day of the next week, man.
Heard Ms.
B.
E.
Hazurika.
Hazurika, learned counsel for the review petitioner. Also heard Mr. A.R. Sigdar, the learned counsel for the respondent who submits that they have filed an affidavit in opposition, a written objection in this case, which has not been placed along with the record, and praise for directing the registry to place the same and list the matter on some other day. Prayer is allowed. Let this matter be listed. 5th of August.
Obligations.
Item 40.
Right, please, Omars. As per the office note dated 29, it got off.
Now, in this case, my lord, we have not received the registered post, but they have not taken the user's process also. But I had the constructive notice because the execution case was stayed by this honorable court because.
Lordship, as per the office note, Lordship, already we have taken steps on the both the way. Register as well as
Lordship,
usual
kindly
process.
see the office note, my lord. They have not submitted the usual process, my lord. So, my lord, I am on the point that they'll serve me a copy, my lord, today. And thereafter, my lord, on the next week, any day, my lord, this review petition will be heard, my lord.
Okay. Heard, Mr.
Let them file Wakalnama first.
Oh, I filed, my lord. Today itself I
Yes,
filed.
what heard, Mr.
AJ Hazarika.
A.J. Hazurika, learned counsel for the review petitioner. Mr. A. Tiwari, learned counsel for the respondent, appears and submits that he would be filing wakalat.
I filed, my
He
lord.
has already filed wakalatnama in this case. And however, he has not received the copy of review petition and therefore prays for directing the review petitioner to furnish a copy of the review petition along with annexures. The review petitioner shall do so within the course of the day.
That's today, on Monday.
Otherwise, my lord, they will not serve. We know that, my
Already it
know
is
that.
on the board.
Otherwise, they could have,
On,
my lord, they could
on
have taken
Monday,
steps, my lord,
Monday.
properly.
Within
2013, I've been fighting for my shop, my lord.
within
What
2
problem?
days, within 2 days from the date of this order, let this matter be listed when for hearing.
Next week, any day, in the top of the list. Any day. Or as per lordship,
After
as per
14,
lordship.
after 14. Twentieth, 20th August.
Interim order may be continued.
The interim order shall continue till next.
High levels.
Deep level.
Item 42.
Lordship, in this case, TCR has been received and all the respondents have been duly represented. Lordship, I am appearing for respondent number 1 to 5. And 50% perhaps has been deposited.
Yes. My lord, as per order dated 22/6/2006, respondent number 6 and 7 also appeared. My lord.
Miss B.
Lordship, my humble prayer would be, Lordship, that if I file a petition to withdrawal of that 50%, they will have a objection because the dispute arises that the person died not out of road traffic accident. So, Lordship, my humble prayer will be any date possible, Lordship, matter is for hearing this. So the parties are not getting any amount.
Miss B. Thakuri,
P. Bora,
Miss P. Bora,
appearing on behalf of Mr. P. Hazarika.
appearing on behalf of Mr. P. Hazarika, learned counsel for the appellant. Also, Mr. S. N. Krishnatreya, appearing for
1 to 5.
respondent number 1 to 5. The appearance of the service of notice on all the respondents is complete, and the records of the concerned MAC case, MAC case have already been received. Hence, let this matter be listed for hearing after 4 weeks,
Let me fix those, otherwise it won't be get listed.
17 November.
Please, Your Lordship.
Deeply.
Item 43.
Appearance is complete.
1 to 5 we appear.
6.
And 7 also, Lordship. It's a air system.
Respondent number 6.
6 and 7 also, Kalatana, as per the cause list, the air system has appeared for the respondent number 6 and 7.
But nothing is there on record. Heard Mr.
But, although I will admit it, interim not granted. So if the interim granted, then let the pay 50%.
You are praying for it.
Not paid much.
You're
50% maybe.
heard Mr. K.K. Bhatto in main appeal. Also heard Mr.
Yeah.
J. Ahmed.
My
Learned,
name is there, but my name not reflected.
learned counsel for respondent number 125.
125.
Who is appearing for 6?
As Islam.
Some Islam appear, not some.
Sorry, as Islam has appeared for respondent 6 and 7.
In
I will
IA,
inform.
in none has appeared for respondent number 6 and 7.
Yeah.
I saw there was a delay in this case.
The delay is condoned.
No, 6 and 7 has appeared in delay condonation application.
For the main appeal, I will inform. I know it.
Okay. Learned counsel for the claimant respondent submits that Mr. J, who is appearing for?
Yes, Islam.
Yes,
Mr. S. Islam is appearing for respondent numbers 6 and 7, and he shall inform him regarding this case. The records of the concerned MAC case has not yet been received. Hence, issue reminder for requisitioning of MAC case number 131/2022 from the concerned tribunal. Registry to take steps for issuance of reminder. Let this matter be listed after 4 weeks on a date to be fixed by registry. In I, same, heard Mr. K.K. Bhatto and J. Islam. This interlocutory application has been filed by the applicant insurance company in connection with MAC appeal number 278/2006, praying for stay of execution of the impugned judgment and award dated 10/11/2025, passed by the Motor Accident Claims Tribunal, Valpara, in MAC case number 131/2022. The applicant insurance company is agreeable to agreeable to deposit of 50% of the awarded amount as condition for grant of stay in this case. Learned counsel for the claimant respondent has not objected to the prayer. Hence, considering the submissions made by the learned counsel for both sides, as well as the averments made in this interlocutory application, this interlocutory application is allowed. The execution of the impugned judgment and award dated 10/11/2025 passed in MAC case number 131/2022 by the Motor Accident Claims Tribunal in Valpara shall remain stayed subject to deposit of 50% of the awarded amount
With interest.
with interest by the applicant insurance company before the registry of this court within 4 weeks from the date of this order. Stop. On such deposit, the said amount shall be disbursed by the applicant, by the registry to the claimant respondent
subject to
after
furnishing one.
after proper verification. You are challenging the quantum only,
Quantum and permit also.
subject to furnishing of a bond of the amount equivalent to the amount disbursed to them. This interlocutory application is accordingly disposed of.
Copy not, appeal copy not.
In appeal এক লাইন লিখি দিব. The appellant shall furnish a copy of memo of appeal along with annexure to the learned counsel for the respondents within 7 days from the date of this order.
Hello.
44.
May Lordships, as per office note dated 28/7 Lordships, and service reports awaited for all the. Already one is appeared.
Lord Mr. R. Burua, the learned counsel for the appellant. Also Miss U. Bihani, learned counsel appearing for respondent number 1 and who submits that she would be filing wakalatnama in this case shortly. On perusal of the office note dated 28/7/2026, it appears that service report in respect of remaining respondents is awaited. The registry is directed to place the postal track consignment report of notices issued to the respondent number 1, 2, and respondent number 2, 3, and 4 by speed post before this court on the next date fixed. List accordingly. After list accordingly on 2nd of September.
Deep level.
45.
My pleasure, Lordship. We already taken steps. Respondent number 2 and 3. But respondent number 2's address was wrong. So,
What is your name?
A.C. Yasmin.
Heard Miss S. Yasmin.
On behalf of
Heard Miss S. Yasmin, learned counsel for the appellant. On perusal of the office note dated 23/6/2026, it appears that
on behalf of R.S. Chaudhary. Lordship.
that the notice service report in respect of respondent number 1 and 3
2 and 3.
1 and 3 is awaited, whereas unserved notice in respect of respondent number 2 has returned back with postal endorsement within inverted comma insufficient address. As such, the appellant is directed to take fresh steps for issuance of notice upon respondent number 2 at his proper address within 7 days from the date of this order, returnable on 7 September. The registry is directed to place the postal track consignment report of the notice issued to respondent number 1 and 3 by speed post before this court on the next date fixed. List accordingly.
46.
Lordship, kindly pass over for the time being. My senior is in legs.
Well, there no condonation petition filed, my lord, along with the RA.
My lord, another thing, my lord, this is I think the transport department is hearing. So what has happened, they must be having some problem because what he has said has matched with our problem. I have a note from the office of the government of Assam that our file was not found.
We have also not.
He has also not received, and I am the state of Assam, and we are arraigned as one of the main appellant, and we have not been served. Now, this is very dangerous, man. We are supposed to be appellant, and we don't even know what is going on.
There is no RFA petition, madam.
Yes. And
There is a division bench order also.
Junior lawyer, my lord, somebody senior may come and.
Who will be coming?
MD Bora, standing.
Let him come.
That's right.
We'll take it up after some time.
Fix a date, my lord, because they will get time to rectify their mistake. And my lord will save the court's time. Let them have 2 days. And we can rectify the omissions, man.
My lord, in 46, my lord, this matter, there are 2 eyes, my lord. My lord may perhaps close the eyes because, my lord, the order has been stayed already and the delay has been condoned.
Bye.
My lord, let me give me 1 moment. My lord, let me see IA 783 of 2026.
No, what is the history of this case?
My
It
lord,
was before division bench.
my lord,
What happened in this case?
my lord, what had happened is that there was a title suit.
Putul? Yes.
There was a title suit which was ordered against us. Subsequently, an appeal was filed in the Bongaigaon District Court. Because due to the change in the pecuniary jurisdiction, the matter was transferred to the High Court.
Okay.
In the High Court matter state pending, the matter was not listed. Therefore, the Narendranath Sharma, the original petitioners, they filed a CRP for listing of the matter. But then the High Court Standing Counsel might have informed that the file was not present and it needed to be reconstructed.
RFA not filed.
File means
Original records did not file that.
My lord, since it was transferred, there was a notification of the Honorable Court that this would be directly done by the registry. It will directly be listed by the registry. But since that was not done, the original petitioners, they filed a CRP stating that the matter should be listed.
thereafter.
Thereafter, my lord, the file was reconstructed. The same was informed to the
File of the appeal, records of
my
the
lord.
appeal.
My lord, may see the order. Is what a copy, my lord. Well, after all the order is there in the main RFA here, that the petitioners, we and the High Court registry together reconstructed whatever documents were available, and then the file was reconstructed.
I have given the record.
My senior has also given.
28/126, there is the order, my lord.
Order where, in which,
A division bench order.
In the CRP, my lord.
why it went to division bench?
Because, my lord, they did not find out the records, my lord, original records. Thereafter, a matter was referred before the honorable division bench. Division bench again referred to that the law, the matter first construct, the record again. Thereafter, it will come automatically in the roster honorable single judgment. So there is a CRP IO. The order has been passed 28/126. Amount was 3,90,000, my lord, only for requisition of the amount, my lord. It has now more than 50 lakhs. Only because lapses.
No, why this first appeal went before a division bench?
Oh, my lord, what has happened is, when the matter was transferred to the High Court, the matter should have automatically been listed here as an RFA. But it stayed pending. Therefore, my lord, the first Narendranath Sharma, they filed the RTI seeking whether the matter has been filed or not. But since no reply was filed, they filed another case for listing of the matter. Then it was found.
Earlier, no RFA was filed.
No, my lord, since the original title appeal was transferred and it should have been listed as an RFA in the Honorable Court, my lord. Because it was a transferred case, my lord. But since that was not done, they had filed a case. And Subsequently, it was found out that the Honorable High Court registry records were not present and it needed to be reconstructed. After reconstruction, this RFA has been numbered.
One IA is also filed, my lord, in our,
Now, what I am repeatedly asking, even if it is CRPIO or RFA, why it went to division bench?
yes, my lord. Because CRPIO has been disposed of. CRPIO has been disposed
That
of.
is not my question.
Yes, my lord.
My question is why it went to a division bench?
Because of, my lord, the registry, my lord, referred the matter before the division bench.
Where is that order?
That is, my lord, CRPIO, they have filed one petition, my lord. IAC number 3690. In CRPIO, in my case, and they have annexed two papers, my lord, regarding matter was before the Honorable Chief Justice.
The High Court.
No need to get a standing counsel. Page 18.
This appeal is against which order?
This appeal is against the order, my lord. Title appeal was filed, my lord, in the year, my lord, 21, my lord. During the pendency of the appeal, as the amount was
That was not my question.
Lordship.
Which is the impugn order?
Yes, my impugn order, my lord, against the title suit order, it will be, my lord. 22/8/19. Because the title appeal was pending, they are in the Bongaigaon court, my lord. Matter referred here to the Honorable High Court, my lord, as amount was more than the 10 lakhs. So, my lord.
So whether appeal lies before a division bench,
No,
then why it went to division bench?
I don't know, because these.
You go through the records. Yes, what is your name?
Well, RB Goswami.
Mr. Goswami, go through the record.
But here is a PRP petition. My lord, if I may read out the prayer.
Yes.
My lord. In the premises aforesaid, it is prayed that your lordship may be pleased to admit the petition, call for records of the case, issue rule calling upon the opposite parties to show cause as to why the impugned order dated 2/6/25 and 4/7/25 passed by the learned Civil Judge, Senior Division, Bongaigaon in title execution 3/2020 should not be set aside and quashed by allowing the petitioners to file allowing the petitions filed by the petitioner in title execution so and so in the Bongaigaon Civil Judge be set aside, the impugned order dated so and so in title appeal. My lord, since the case was not listed, the petitioners, the Narendranath Sharma, he approached the court.
No, that was not my question.
My lord, no, what had happened, my lord, because the matter was not listed, they filed another subsequent case.
That
apart
was
from
also.
the title.
Have you understood my question?
Yes, my lord. I
What
have
is?
to check up the records, why matter has been.
Because there is a notification that the matter pertaining to staff of High Court,
Yes,
whether any staff of High Court or subordinate court is involved in this case.
Yes, my lord. One action, Lotus Hill Police Station, Ezahara also.
You answer my query on the next day, and
Yes.
both of you go through the records.
Yes.
My lord, Mayor, my lord will report that we have got State of Assam office of State of the High Court. That file was not found and we are not involved in this thing now. Because what Mrs. Degat said, that the initial amount was 9 lakh something, yes?
3 lakhs 90.
3 lakhs something, and now it has become 50 lakhs something. So that will be the main reason, man. And our office may not be involved, that is all.
Anyway, your lordship fix it in another day. We'll see.
And all cooperation from our office will be received by the respondent. No, the citizen, some citizen of this state may suffer, man. That is what I'm saying.
This has been filed
The
by the.
transport of
Who is
part
transport?
of the state of Assam.
Transport Department.
My lord, I'm going for the transport department.
On last occasion, a prayer
My
was
lord.
made that
I have received the title appeal, my lord. I have received the copy. I checked the records. The IA's copies are not there in the records as well. but the order is present by which the appeal was allowed and the order was stayed
By the trial, by
by the trial court, in title appeal 1/2021,
no, by the appellate court
appellate court,
before the district
Yes,
district judge board.
district judges court.
Well,
Because they are a department of the state of Assam. So we are concerned.
Now, what is the pair?
my lord, IA 783 and IA 784, those, my lord, the players in those IAs has already been granted. One is for condonation of delay and one was for stay of the order of the in the title suit
Granted by which?
by the title by the Bongaigaon district court, my lord.
Where are those?
My lord, it's there in the IA, my lord, order dated 23/21. My lord, make his face one moment. My lord, may pick up the main RFA. It's there in page number 46. Annexure number 5 in the RFA, my lord. Because the RFA has all the documents, the other files do not have it. My lord, may pick up the RFA. RFA 23 of 26.
Yes.
Which case?
Page number 46, my lord.
That was the title appeal execution process more possible.
My lord, okay, my lord.
Yes.
Page 46, my lord. This is in Miss J 2 of 2021, which has now been numbered as IA 783/26. Order dated 23/2021. If I may read, my lord. Parties are represented, heard both sides. With the following order, I propose to dispose of Miss J case. This Miss J case number 2 of 2021 has arisen out of title appeal 1 of 21. The petition number 5 of 21 filed under order 41 rule 5 read with section 151 of CPC by the petitioner praying for stay of execution of the judgment and decree passed in title suit 53/16 and in view of the order dated 23/21 passed in title appeal 1 of 21 admitting the appeal for hearing, the execution of the impugned judgment and order passed in the title suit number 53/2016 is hereby stayed till disposal of the appeal. The Miss J case stands disposed of accordingly. So, my lord, the condonation of delay was also granted and the title suit order has also been
It was
stayed.
in the title appeal.
In the title appeal, it has been stayed. The title suit order has been stayed.
Okay. Then where is the memo of appeal?
The memo of appeal having further things.
Whether. Okay. Heard, Mr. What is your name?
R.B. Goswami.
R.B. Goswami.
Standing counsel.
The learned counsel. Standing counsel.
Transport, madam.
Standing counsel, Transport Department, appearing for the appellant.
Number two,
Or-
madam, I'm appealing only for 2 and 4, my lord. 2 and 4 are transport department. The rest, my lord, my senior will appear for the government entity.
Who is for?
G,
One.
G Assam.
I'm appearing for all the state of Assam parties.
Also Mr. K.K. Bhattacharya. And Mr. Bora appearing for respondent number 2 and 4. Whereas Mr. K.K. Bhattacharya appears for respondent number 1 and 3. It is submitted by learned counsel for the not respondent, appellant. Appellant number 2 and 4. Also Mr. H. Das appearing for the sole respondent.
Yes.
This regular first appeal has been registered This division bench order has been passed in which case?
CRP 342, 2025.
28/1/26.
Registered on the basis of order of the division bench passed in IA within bracket civil number 3690/2025. After reconstruction of the records of the original title appeal, which was transferred to this court from the Court of London, District Judge Bongaigaon. The original before the London District Judge Bongaigaon, the title appeal was registered as
1/21.
1/2021. However, same has been re-registered in pursuant to the aforesaid judgment of the division bench as RFA number 23/2026. Learned counsel for the appellant number 2, Mr. R.B. Goswami, submits that though the IA 783 has, though record of IA number 783 has also been reconstructed, as well as record of IA number
784/26.
784 Putul 784 due. 784 have also been reconstructed. The said interlocutory application were filed pertains to the condonation of delay in preferring the appeal, as well as grant of stay of execution of the impugned judgment during the pendency of the appeal. However, he submits that the said prayer was already allowed by the
District Judge.
Court of London, District Judge Bongaigaon, by its order dated 23/22/21, passed in Ms. J case number 2/2021, whereby the judgment impugned in the connected appeal, in this appeal has already been whereby the execution of the judgment impugned in the instant appeal has already been stayed during the till disposal of the appeal, as well as delay was also
Delay was also condoned, my lord.
by which
Order is in the same date, my lord. My lord, may read the same order, my lord. If I may read again, my lord, the petition number 5/21 filed under order 41 rule 5 read with 151 CPC. The petitioner was paying for stay of execution of the impugned judgment and decree passed in title suit 53/2016, and in view of the order dated 23/21 passed in title appeal admitting the appeal for hearing, the execution of the impugned judgment and order passed in so and so is stayed. On the same date, both, my lord. One, that was title appeal.
last line. Stay. Stop. He therefore submits that the interlocutory applications, namely IA Civil number 783/2026 and IA Civil 784/2026 have become infructuous and same may be closed. The prayer is allowed. এই দুটা আয়াত লিখিব in view of the order passed in the today in the connected first appeal, these interlocutory applications are disposed of. In appeal continue koribo. What was your submission, Mr. Bhattacharya?
My lord, whatever has happened, I think now this case is being heard by the district judge. So
No,
they-
no.
No, not.
Now this has to be heard by this court.
This court, this one.
It was originally before the district judge. Due to change of pecuniary limitations, it was transferred to this court.
This court.
But during that time, the two IAs were allowed already.
Yes, yes, that I have reflected. Now this appeal is to be heard.
Shortly, my lord.
Trial
What
court.
has happened? So what we can do to save time, do it in a way so that nobody gets into any trouble. That is what I'm suggesting.
We are
First
fixing
thing
it
is
for
that-
hearing.
Yes,
Parties are there.
just I have to receive the copy RF.
I so furnish a copy, my lord.
Release this appeal for where are the trial court records?
These are the trial court records, there's
They
no
are
other record.
constructed subsequently.
This much record, only reconstructed.
Yes,
record.
my lord.
And the copies will have to be served, my lord.
The registry, who reconstructed registry? Yes, the registry shall furnish copies of the memo of appeal and annexures from the reconstructed records of this regular first appeal to learned counsel for all the parties involved in this case before the next date fixed. Let this matter be listed for hearing on.
Orders, first they look the proper, my lord gets a date.
Already.
Let it listed for hearing. If on that date any difficulty arise, you apprise the court on that date.
Because already number raised that case is raised that. Record also.
In orders column on date at the due. On 2nd of September.
My lord has reflected that the IA has become infructuous. My lord may kindly record that the order will sustain, my lord, order of the titler.
No, that I have mentioned.
My lord.
The registry can work in coordination with our office.
That they will do.
Keep your best.
We will do whatever is necessary. Item 47.
Ma'am, please, your lordship. Lordship, as per office note dated 28/7/26, the counsel for respondent number 1 has entered appearance. And for respondent number 2, the notice is delivered on 30/4/26.
How many respondents are there?
2 respondents.
You are appearing for?
Venture one,
One.
respondent one.
Okay. What is this?
Delay
Delay.
petition.
You will be filing objection or condoning?
Lordship, 24 days delay, not
Okay.
properly explained, but I leave it to Lordship.
Heard Miss
As Patwari.
S. Patwari, learned counsel for the applicant. Also heard Miss R.D. Majumdar, learned counsel for respondent number 1. On perusal of the office note dated 28/7/2026, it appears that the notice issued to respondent number 2 has been duly served. This application under section 5 of the Limitation Act has been filed by the applicant, Mr. Abu Sahed, alias Abu Sahed, praying for condoning the delay of 24 days in preferring the connected MAC appeal, whereby judgment and order dated 8/8/2025 passed by the Motor Accident Claims Tribunal, Morigao, in MAC case number MAC within bracket injury case number 76/2018 has been impugned. The cause of delay in preferring the connected appeal has been stated by the applicant in
Paragraph number 3 and 4.
paragraph number 3 and 4. No, a line to Ragot Likho, the learned counsel for the applicant has submitted that the reasons for delay has been stated by the applicant in paragraph number 3 and 4. On the other hand, learned counsel for the respondent number, opposite parties number 1 has objected to the prayer for condonation of delay on the ground that delay has not been sufficiently explained. I have gone through the grounds stated in the instant interlocutory application. It appears that the reasons shown by the applicant in the instant interlocutory application may be regarded as sufficient cause which prevented him from preferring the connected appeal within the prescribed period of limitation. As such, the delay of 24 days in preferring the connected appeal is hereby condoned, and this interlocutory application is allowed. The registry is directed to register the connected MAC appeal and list the same for admission or on a day to be fixed by it after a week.
Much on that.
Mid-pick, Lordship. In this case, Lordship, I file IFR within 50%, Lordship.
Lordship, we have filed our objection to that, but that is not on record, Your Lordship. We have filed it on 17/7/2026. Your Lordship, that may be tagged and it may be.
Mr. D.
Mohanta.
D. Mohanta, learned counsel for the applicant. Also, Ms. P. Borthakur, learned counsel for the opposite party, who submits that the opposite party has filed written objection to the interlocutory application filed by the applicant. However, same has not been placed with the record. Hence, she prays for directing the registry to do so. Stop. Registry shall tag the written objection filed by the insurance company along with this interlocutory application on the next date fixed. Please this matter. 21st August.
Outlines.
Please, Your Lordship. Lordship, I filed this I for withdrawal of the amount, Lordship, which has already been deposited.
Lordship, we may be given 2 weeks time to file our objection, Your Lordship. The appeal is not on quota.
Not on count.
Yes, sir.
Heard Ms. P. Barua, learned counsel for the applicant. Also heard Ms. P. Borthakur, learned counsel for the opposite party appellants. This interlocutory application has been filed by the applicant/claimant praying for allowing the applicant claimant to withdraw the 50% of the awarded amount which has been deposited by the insurance company before the registry of this court in pursuant to the order of this court. Ms. P. Borthakur, the learned counsel for the insurance company prays for some time for filing written objection against the instant interlocutory application. The prayer is allowed. Let this matter be listed. 2nd September.
Okay.
May it please your lordship. My lord, the interlocutory application has been filed by the appellant in the RFA, which was pending and which was at the stage of final hearing
being fixed for final hearing on 18th of August. Now, in between, what has happened is the respondent bank has issued an auction sale notice that your lordship will find at page 29, wherein the sued property, which is the subject matter of dispute since the trial through to this first appeal. Now, this has been sought to be put to sale. Now, your lordship will kindly appreciate that at the time of filing of this first appeal, there was earlier an interlocutory application filed under Order 39, Rule 1 and 2 CPC, wherein your lordship had passed an order dated 13/5/2026, that is at page 22. If your lordship kindly comes to page 22 for a while, madam. Now, your lordship, I'll first of all, my lord, take your lordship to page number 20. This is an order passed by your lordship in IA 949 of 2026. The operative part your lordship will find at page 20. Now, your lordship will kindly take up paragraph 5 onwards, wherein, my lord, on being asked as to whether the bank had proceeded for putting the suit property to sale, my lord, this was the recording. He submits that as the suit filed by the present applicant has been dismissed, he apprehends that bank may now proceed for auction sale of the suit property. However, he fairly submits that as on today, he is not aware of any such steps taken by the respondent bank. Under the aforesaid circumstances, let the notice be issued to the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on such and such. The applicant shall be at liberty to approach this court on a prior date if he gets an intimation regarding any attempt of the respondent bank of selling the suit property in auction. Now, this was the liberty given by this honorable court at the time of admission of the appeal and also for consideration of this IA. Now, subsequently, your lordship, I'll just take a few minutes, my lord. Subsequently, again, when this matter came up on 13/5/2026 before this honorable court, on that date also, there was no action by the bank to put the property to auction sale, and therefore, my lord, there was a prayer for withdrawing this IA as no injunction or stay or any interim protection was thought necessary at that point of time. Now, your lordship kindly sees the next order, that is at page 25, that is in the main appeal. Now, at page number 26, your lordship will kindly see on appreciation of the office note to the extent that service upon the respondents are complete and records have also been received. This matter was directed to be revisited for hearing on 18/8/2026, that your lordship will find at page number 27. That is the order dated. This order is dated 17/6/2026. Now, after all this, on 18/7/2026 at page 29, this e-auction notice has been issued by the bank. It is not that the bank is not aware of the pendency of this appeal, because my learned friend has been appearing in this matter, and the last order was on 17/6.
When is the date of e-auction?
Deeply, my lord?
When is the date fixed for?
My lord, the auction sale notice reveals that the date and time of the e-auction is 24/8/2026 in respect of the property that is the subject matter of concern in this case, and the earnest money deposits have already started to be invited, the last date having been fixed on 23/8/2026. So the earnest money, someone can, because the e-auction sale notice has already been issued, so earnest money deposits are being taken. It is open for any bidders to deposit the earnest money.
What is your submission?
Your lordship, this application is filed by suppressing the facts. In fact, when the bank had taken steps under the SARFAESI Act, the petitioner approached DRT Gauhati, and her SARFAESI application was dismissed by the SARFAESI. by the DRT. It was dismissed on 17/10/2016. Apart from this, bank has also filed original application before the DRT, and that application is allowed, holding the petitioner liable to pay the amount.
The
Against the SARFAESI order,
impugned decree has been passed in which case?
That is in title suit number 29 of 2016, my lord.
What was the decree?
That was a decree pursuant to a suit filed by us, wherein we challenged the creation of the equitable mortgage on the ground of fraud.
Suit was dismissed.
And the suit was dismissed, against which we have filed the RFA. And in the judgment and decree passed in the suit, there is mention of all the things which my learned friend is saying regarding the filing of SARFAESI on previous occasion against the notice under SARFAESI, then their OA and the judgment and order passed in the OA. Now, my lord, here what my humble submission is, this is a regular first appeal which has been admitted against a judgment and a decree, and the final hearing of which is pending and fixed on 17th of August, and to the knowledge of the bank. Now, as if, my lord, this appeal is going in favor of the bank, this is the assumption that has been taken by the bank in fixing, in issuing this e-auction sale notice. And of course, my lord has rightly seen that the date of e-auction has been fixed a few days after the date of final hearing. But the auction sale notice, the issuance of auction sale notice itself, my lord, is an indicative of the my lord an understanding by the bank. It is as if they are assuming that this appeal will go in their favor. This appeal is to be heard. Prima facie, this honorable court was satisfied about the making out of a case in the appeal, and that's why this appeal was admitted. They were issued notice, they came, they appeared, and this matter has been fixed for final hearing. Now, in between, during the pendency of the appeal, and that too between this period when the last order was passed in the main appeal and the final, the date of the final hearing, my lord, I fail to understand what on earth is the urgency for them to issue the e-auction sale notice only during this particular period of time, so as to render my appeal infructuous.
Your lordship, the recovery proceeding is pending since 2012. We have waited for 14 years because we are waiting for the order of the DRT in the original application. And against these two orders, no appeal is filed.
My lord, I am not a borrower.
Finality.
I am not a borrower. Insofar as the loan that my learned friend is talking about, I am not a borrower in the loan.
See the mortgages.
I am not the. I am not.
Competent court of jurisdiction.
My lord,
DRT has held it that mortgage was there, and she has created mortgage.
that is why the
Against that, there is no appeal. So same has attained finality.
my lord, we are
And
simply.
section 34 of SARFAESI Act bars jurisdiction of the civil court. Only on that ground, title suit was dismissed.
No, I beg to differ, my lord. The title suit was not dismissed on the ground of bar of jurisdiction, and moreover, me not being the guarantor.
No, otherwise also, the notice will be given effect after the date.
That is what that is there, my lord. But then the EMD, the earnest money deposit that they are now inviting, that is there in the notice itself. Now, this what happens now is there is a creation of third party liability that also comes in, a question of third party, because somebody who will be depositing the earnest money, they obviously will have, my lord, an interest created once they deposit and they are in interest. Now, my respectful submission here is that 18th August is, my lord, a couple of weeks away. Now, I don't find, my lord, a reason why the bank cannot wait for 18th of August, because they otherwise they could have taken this plea.
Otherwise, there is no stay.
Otherwise, there is no stay, but the liberty was given by this honorable court because that's the time when the earlier.
No stay on in the order passed by DRT.
No, DRT, my lord, is a, my lord, proceeding where your lordship will kindly see insofar as the provisions of surface is concerned, that insofar as any action taken under section 13(4) of the Surface Act is concerned, against that the person aggrieved, who can be either a borrower or a guarantor or any other person aggrieved by the action taken by the Surface Act under section 13(4) can approach the debt recovery tribunal under section 17, which was once done on a previous occasion. That resulted in a dismissal of the surface application under section 17, and then the notice that was issued at that point of time, that was not acted upon. Now, this is a fresh notice that they have issued under Surface Act. This is independent of the judgment and order passed in the original application, which is under section 19 of the Recovery of Debts and Bankruptcy Act 1993. These two provisions, statutory provisions, are independent of each other. Now, be that as it may, my lord, we are into a separate litigation where we had challenged the creation of the equitable mortgage under section 58 of the Transfer of Property Act 1881 before the learned court below, before the learned trial civil court. And that suit was dismissed, against which we preferred appeal before this honorable court. Now, this appeal was admitted, taking into consideration the grounds, meaning thereby that this honorable court was satisfied about making out of a prima facie case in the appeal. Now, insofar as the interim application was concerned, the interlocutory application for interim protection was concerned, that your lordship has already seen was not, my lord, the order was not passed in that application at that point of time, because there was no action taken by the bank to put the suit property to sale in auction. Now, liberty was given by this honorable court that once there is any such action taken by the bank, it needs to be brought to the prior notice of this honorable court. Now, this is something that has happened now. And surprisingly, it has happened after some length of time, where this matter has now progressed to a stage of final hearing. My lord, with all respect to the orders of the Debt Recovery Tribunal in the Surface proceeding and in the OA proceeding, there is an appeal pending before this honorable court in which both the parties have appeared, and it has been fixed for final hearing. The judicial decorum at least should have been maintained by the respondent bank, in at least waiting for 18(8).
Yes.
Your lordship, my humble submission is that since no appeal is filed against the order of the DRT in surface application, which has upheld the mortgage and action of the bank under the Surface Act, and bank has issued this notice under the provision of Surface Act. So if he is aggrieved by that notice, he has only one option: again approach the DRT. Simply one RFA is pending. He cannot pray injunction here to restrain the bank to take a statutory action. Bank is entitled, and he has availed all this. Even in the original application, she was party. And the matter is pending since 2012, your lordship.
Heard Mr. B. Chakravarti, the learned counsel for the applicant. Also heard Mr. A. Parvez, the learned counsel for the respondent. This interlocutory application has been filed under Order 39, Rule 1 and 2, read with section. This is coming up for the first time. Will you file any objection?
Your lordship.
Will you be filing any written objection?
Yes, I will file if required, but since I have produced the judicial order, court may take consideration of that also.
You file written objection.
Okay.
The Order 39, Rule 1 and 2, read with section 151 of the Code of Civil Procedure 1908, praying for grant of temporary injunction or restraining the respondent number 1, respondent bank to give effect to e-auction sale notice dated 18/7/2026, whereby the suit property involved in this appeal is sought to be auctioned. The learned counsel for the applicant has submitted that though the date and time of e-auction mentioned in the said notice is 24th August 2026 at 11 a.m. However, the time for depositing the earnest money, where is that?
That is in the left-hand side column, my lord. EMD, last date of deposit of EMD, rupees 29 lakhs, 29.13 lakhs, below, within bracket, 23/8/2026 is the last date. In B, in clause B.
Has been stated in the said notice to be 23/8/2026. Hence, he submits that the operation of the notice issued by respondent bank is required to be stayed, whereas learned counsel for the respondent submits that the notice has been issued under the provisions of the Surface Act 2002 after the application under section 17 of the Surface Act filed by the present petitioner was dismissed by the Debt Recovery Tribunal Gauhati on 17/10/2016 in original application number 33/2012. He submits that no appeal is pending against no appeal has been preferred. No, he submits that the said order dated 17/10/2016 has not been put to challenge by the present petitioner before any forum. He, however, submits that the bank may be allowed to file a written objection against the interlocutory application filed by the petitioner. Stop. The prayer is allowed. Let this matter be listed. No. 7th of August. 7th of August. Since the date of auction is stated in the impugned notice as 24th August 2026, no interim relief is granted at this point of time. Same shall be considered on the next date after filing of written objection by the respondent bank, list accordingly.
My lord, can it be on 11th of August?
11th of August.
Deeply obliged.
That is sorry, my lord. Item 52, my lord. I need to have give written argument, my lord. So hearing is not needed further as because your lordship has already said, my lord, and my written argument I have given. Plus, I have marked the provisions of the law, my lord, yellow mark.
And other side?
Other side they will give. My lord, my part I want to give it. Because, my lord, I'll be preoccupied in court 18.
Okay, you give it to the court.
So I have filed my part, my lord.
Judgment will be reserved.
Oh, there is a one judgment also I have annexed.
No, I'll be reserving the judgment.
My lord,
The judgment will be reserved.
my lord, my lord. Obliged. Item 55.
May it please your lordship. My lord, lordship will kindly see the order passed by Lozima Court, my lord, 22/7/2026. The postal track record, my lord, it reflects that notices on respondent number 3 has been served. Okay. Other respondent 1 and 2 are already represented.
It is what application is?
Delay, my lord,
How much delay?
453 days.
You are opposing?
I am for the respondent, opposite party number 1,
Claimant.
claimant.
It's an injury
Your
case.
lordship, in this case, I have gone through the record. I have filed my written objection, affidavit in opposition. But I could not trace it out on the record.
I have a copy.
I have also one copy. My learned friend is also having a copy. I have filed it on 11/10/23. The
Will
system reflects that.
We'll direct the registry and post it next week.
Yes, service is complete otherwise.
Otherwise, not all the single point ground is there.
Heard Mr. R.K. Batra, the learned counsel for the applicant. Also heard Mr. D. Mondal, the learned counsel appearing for respondent number 1. On perusal of the order dated 22/7/2026 passed by the Lawazima Court, it appears that what happened to 2?
2 is also served, my lord. Earlier it was served.
Earlier order, it was reflected.
It's order dated 2/3/2026.
It appears that notice issued to respondent number 3 has been duly delivered to the addressee. As such, the notice issued to the said respondent is held to be duly served. Stop. The learned counsel for respondent number 1 has submitted that though he has filed written objection against the prayer for condonation of delay made by the present applicant, same is not tagged with the case record. Hence, he prays for directing the registry to tag the same with the record on some other day. The prayer is allowed. Registry to tag the written objection filed by respondent number 1 with the case with this record and list the same again on before 15 day,
Uh,
12th of
No, your lordship, this delay application is of 2018. Already 8 years has passed. So your lordship
first
can
week.
fix it on
7th of August.
7th of.
Obliged.
Admission item 2.
Made, please, your lordship. Your lordship, respondent one is appearing. So far as respondent 2 and 3 is concerned, we did not take steps upon respondent 3, and so far as respondent 2 is concerned, there is a postal remark which says insufficient address. So your lordship, today I am praying for to take steps upon respondent 2 and 3 by way of paper publication.
Heard,
Lordship, my name is not reflected on the cause list.
heard Mr. S. Datta, learned counsel for the appellant. Also heard Mr. K.K. Datta,
D. Datta on behalf of KK Datta.
D. Datta, on behalf of Mr. K.K. Datta, learned counsel for the respondent number 1. Learned counsel for the appellant submits that the notice issued to respondent number 2 and 3 could not be served. Notice issued to respondent number 2 could not be served due to insufficient address. Hence, he prays for allowing the appellant to take steps for issuance of notice upon respondent number 2 and 3 by substituted mode of publication of the notice in the newspaper, which is widely circulated in the last known address of the said respondents. The prayer is allowed. The appellant shall take steps for issuance of notice by publishing the same in the newspaper, circulated widely in the last known address of the respondent number 2 and 3. The date of appearance to be mentioned in the said notice shall be 28th of September. List accordingly. The registry shall reflect the name of Mr. D. Datta as well as Mr. K.K. Datta in the cause list as engaged counsel for respondent number 1 henceforth.
Please, your lordship. Lordship, so far as regards serving of notice, lordship, respondent 5 and 6 is appearing, lordship. Also, office note dated 7/4/26. Service upon respondents 3 to 6 have been completed, lordship. 384 is not appearing, although sir.
1 and 2?
1 and 2, although taking both the steps, through register process, usual process. Through usual process, we came to know about it today, lordship. Respondent 1 and 2 had died long back, expired already, lordship.
So you have to take steps. 1 and 2 both have expired.
Both have expired. It is stated in office note itself, lordship, and also on.
Heard Mr. S. A. Bakhtiar, the learned counsel for the appellant. Also heard Mr. K. Yes, what is the name?
P. Sharma, Lordship.
P. Sharma, the learned counsel for respondent number 5 and 6.
Upon respondent number 3 and 4, it has been served, lordship.
On perusal of office note dated 7/4/2026, it appears that notice issued to respondent number 3 and 4 have been duly served. However, it indicates that notice issued to respondent number 1 and 2 could not be served as both the respondents are reported to have expired. The learned counsel for the appellant submits that in view of the aforesaid office note, some time may be granted to the appellant to take appropriate steps with regard to respondent number 1 and 2. Please this matter again after 4 weeks.
Lordship, before coming to the, regarding the IA Lordship, IA 59, there is a stay Lordship, the execution proceedings. At the same time, appeal has been admitted, but not reflected in the main appeal Lordship, whether it has been admitted or not. But in the IA, it has been stated clearly in paragraph number 7, that appeal has already been admitted and execution proceedings has been set. Can you rectify the?
In main appeal order of this appeal is admitted.
But they have to call it for the records.
The records of the trial court may be requisitioned, registry to take steps for requisitioning the trial court records.
Yes. Not so.
May please, your lordship. A statutory appeal, my lord, against a judgment, my lord, issuing letters of administration, my lord.
Heard Mr. S. Das, the learned counsel for the appellant. This appeal under section 299 of the Indian Succession Act 1925 has been preferred by the appellants, impugning the judgment and order dated 29/5/2026 passed by the Court of London Additional District Judge Bilasipara in Miss LOA case number 1/2018, whereby the petition filed by the respondent for issuance of letters of administration was allowed. Issue notice to the respondent. The appellant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order. Let also records of miss within bracket letters of administration case number 1/2018 be requisitioned from the trial the registry to issue requisition. Let this matter be listed on 7th of September.
IA is there, my lord, till returnable date, my lord.
Issue notice.
IA, my lord. Otherwise, my lord, they will correct the land records on the basis of this order, my lord, till returnable date, my lord. Since a statutory appeal, my lord.
No, we'll issue notice now. On next date, let the notice be issued.
But it's a statutory appeal, my lord.
We'll
Otherwise, my lord, if they go on and my lord, with the execution proceeding, my lord, then my lord,
whether any
yes, execution case is there already, my lord.
what is your ground?
The grounds are several, my lord. And lordship will also see in my main appeal, my lord. At page number, my lord, 25. Before this petition was even filed, we had filed this title suit 123 of 2016, my lord, challenging the validity of the will. That suit is still pending, and without even discussing anything about this suit, my lord, this LOA has been issued, my lord. This suit is still pending. Lordship will see the prayer, my lord, at page number 29. There is a specific prayer that that this decree declaring that the will was obtained illegally and practicing fraud. So this issue is still pending. It's a live issue, my lord.
Executor has died.
Yes.
Yes, in the year 2010, the will was issued. 12, he died. We filed this, my lord, title suit in the year 2016. They filed this LOA in the year 2017, my lord.
Heard Mr. S. Das, learned counsel for the applicant. This application under Order 41, Rule 5 of the Code of Civil Procedure has been filed in connection with the testamentary appeal number 11/2026, whereby appeal number 11/2026, praying for stay of execution of the judgment and order dated 29/5/2026, passed by the Court of London, Additional District Judge Pilasipara, in Miss within bracket letters of administration bracket close, case number 1/2018, whereby letters of administration was issued in favor of the respondent. Learned counsel for the applicant submits that the connected testamentary appeal has been admitted. In the appeal, appeal is admitted, likhbo appeal. Admitted and notices have been issued to the respondent. As such, he prays for staying the execution of the impugned judgment till the pendency of the connected appeal. Stop issue notice to the respondent opposite parties. The applicant shall take steps for issuance of notice upon opposite parties by speed post as well as by usual note within 7 days from the date of this order, returnable on 7 September. However, since the appeal has been admitted till next returnable date, the execution of impugned judgment and order dated 29/5/2026 shall remain stayed. Stop. List accordingly.
Highly obliged.
Regarding item number 3, interim with protection sales, interim may be extended to weeks.
Item number?
Item number 3.
The interim order shall continue. Detail.
Next item.
Item 52, you submit the written objection. Item 52, both the parties have submitted their written gist of argument. Hearing concluded, judgment reserved.
But in this appeal, my lord, we have taken steps, my lord. So service is awaited, my lord, and the records are yet to be received, my lord. So
Heard Mr. S. Das, learned counsel for the appellant. On perusal of the office note dated 28/7/2026, it appears that service report in respect of notices issued to the respondent is awaited. The registry is directed to place postal track consignment report of notices issued to the respondents by speed post before this court on the next date fixed. The registry shall also issue reminder for the trial court records. Let this matter be listed again on 7th of September.
highly obliged. Item 6. My lord, this is the first day. This is the appeal against decree of divorce, as well as maintenance of permanent alimony.
Heard Mr. M. Das.
D. Kenap, my
D. Kenap, learned counsel for the appellant. This appeal under Section 28 of the Hindu Marriage Act 1955 has been preferred by the appellant Shri Padum Chandra Das, impugning the judgment and order dated 25/2026, passed in title suit M within bracket M number 51/2021. Divorce was granted or refused?
Granted, my lord. I am the husband
Stop.
and divorce was filed by the wife.
Okay. After going through the grounds stated in the memo of appeal and considering the submissions made by learned counsel for the appellant, this appeal is admitted. Let the records of trial court may be requisitioned. Let the records of trial court be requisitioned. The registry shall take steps for requisitioning the aforesaid records. Let also notice be issued to the respondent. The appellant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable 9 September.
Well, there is the lump sum amount of 5 lakhs has been directed to pay. But the problem is this, my lord, the financial condition of the appellant is not good that he could pay. He is agreed to pay the monthly amount. The earlier, my lord, monthly maintenance amount of rupees 2000 was paid, allowed, because his
by the District Court of London, District Judge Sibsagar in title suit within bracket M number 51/2021, as well as NIS case number 28/2021. Issue notice to the opposite parties. The applicant shall take steps for issuance of notice by speed post as well as by usual mode within 7 days, returnable on 9 September. The prayer for interim relief shall be considered only after due service of notice upon the opposite party.
May I please your lordship? The present appeal is preferred under section 23 of the Railway Claims Tribunal Act, challenging the impugned judgment passed by Railway Claims Tribunal.
Miss you
U. Bihani. Yes, lordship.
learned counsel for the
sole respondent, lord.
appellant. Also Mr. S. Chakravarti appearing for the sole respondent. This appeal under section 23 of the Railway Claims Tribunal Act 1987 has been preferred against the judgment and order dated 27/5/2026, passed in original application number OA within bracket I/GHY/05/24 within bracket old of the Railway Claims Tribunal, Gauhati bench. Stop. This appeal is admitted. Issue notice. Since Mr. Chakravarti has already appeared for the sole respondent, no formal notice need to be issued. No formal steps are required to be taken for issuance of notice. You have received the memo. The appellant is directed to furnish requisite numbers of extra copies of the memo of appeal along with annexure to the learned counsel for the respondent. Let the records of the trial court be called for. The registry to take steps for requisitioning the records. Let this matter be listed. 9 September.
Okay, only one pair. My name may be reflected in the
Name of Mr. S. Chakravarti may be reflected in the cause list as engaged counsel for the respondent. Henceforth.
My lords, similar order may be passed and
N Upadhyay for the respondent, full respondent also.
Same order.
yes, lordship.
Name of the council will be N Upadhyay in place of S Chakravarti. And case number will be different, recorded by sir.
And my similar prayer would be also in the call is kindly so.
Yes, same order. Order I
Yes.
can.
Obliged.
Date 9 September.
Item 9.
What is your name?
DJ Das, your lordship.
D.
DJ Das, your lordship.
DJ Das. Same order, same date. 9th of September. 9 September.
Lordship.
My lord, similar order in 10 order.
Then also same order, R. Sharma.
Item 12 is similar also.
Separate date. 10th or 11 September. And 11,
Item 11.
11.
My lords,
VK Chopra.
similar order.
VK Chopra, date पे लिख दीजिए. 11 September. 12,
My lord, similar order.
DJ Das. DJ Das, date पे लिख दीजिए. 13,
Nice, obliged, my lord.
Appeal, your lordship. Appeal statutory appeal on the ground.
Mr. R. Sharma, learned counsel for the appellants. This appeal under section 173 of Motor Vehicles Act has been preferred by the appellant, namely Oriental Insurance Company Limited, impugning the judgment and award dated 17/7/2025, passed by the Motor Accident Claims Tribunal of Kimpur in MSC case number 29/2022. I have considered the grounds stated in the memo of appeal and have heard learned counsel for the appellant. This appeal is admitted. Let the records of MSC case number 29/2022 be called for from the concerned tribunal registry to take steps for requisitioning the records. Let also notice be issued to the respondents. The appellant shall take steps for issuance of notice upon the respondents within 7 days by speed post as well as by usual mode within returnable on 11 September.
We are ready to deposit 50%.
I
Item number 9, my lord, SCGSC, my lord, my name may be reflected. H Das.
My senior friends may be recorded.
item number 9
9 H Das.
H Das instead of DJ Das, H Das. This interlocutory heard Mr. R. Sharma, learned counsel for the applicant. This interlocutory application has been filed by the applicant insurance company in connection with MAC appeal number 147/2027, praying for staying the execution of the impugned judgment and award dated 17/7/2025, passed by the Motor Accident Claims Tribunal, Lakhimpur, in MSC case number 29/2022. The learned counsel for the applicant submits that the applicant insurance company is agreeable to deposit 50% of the awarded amount as a condition for grant of stay of the impugned judgment and award. Stop. Considering the submissions made by learned counsel for the applicant. The notice to opposite parties is waived and this interlocutory application is allowed. The execution of impugned judgment and award dated 17/7/2025 passed in MSC case number 29/2022 shall remain stayed during the pendency of the connected appeal, connected MAC appeal number 147/2026, subject to deposit of 50% of the awarded amount by the insurance company before the registry of this court within a period of
6 weeks.
6 weeks. This interlocutory application is accordingly disposed of.
Apply, Lordship.
May it please your lordship. Your lordship, we have filed this appeal on the ground of compassionate family pension scheme. Lordship, in this case, was a government employee, and as such, the family members are entitled for this scheme.
But Ms. Argus, Ms. P. Thakur, learned counsel for the appellant, also heard Ms. P. Bora, learned counsel for
The respondent, Lordship.
claimant.
Claiming. 1 and 2.
Learned counsel for respondent number 1 and 2 / claimant. This appeal under section 173 of the Motor Vehicles Act 1988 has been preferred by the appellant insurance company, impugning the judgment and award dated 9/9/2024 passed by the Motor Accident Claims Tribunal, Morigao, in MAC within bracket death case number 3/2020. Directing the appellant to pay a compensation amount of rupees 65,72,200 to the claimant's respondent. I have considered the grounds stated in the memo of appeal. This appeal is admitted. Let the records of MAC within bracket death case number 3/2020 be called for from the concerned tribunal. Let also notice be issued to the respondents. Since Ms. Bora has already appeared for respondent number 1 and 2, no formal notice need to be issued to the said respondents. You have received. As regards other respondents, the appellant shall take steps for issuance of notice to them by speed post as well as by usual mode within 7 days from the date of this order, returnable on 11th September.
Lordship, there is an IA for stay. Your Lordship, at this stage, we shall deposit 25% of the awarded amount, Your Lordship.
Lordship, to that we have objection. At least 50% of the
Lordship, in
awarded
this
amount.
case, our main contention is that since the claimants are already entitled for 100% of the last drawn salary of the deceased, so the question of loss of dependency doesn't arise here, Your Lordship.
How you address? What is your response to that?
In that regard, this matter may be fixed for another date.
You filed. Okay.
Lordship, in several other cases on the same ground, Gauhati High Court is granting stay subject to deposit of 20% of the awarded amount.
You are not filing execution now. We'll decide this on the next date. Let her come prepared. Heard Ms. P. Thakur, learned counsel for the applicant. Also heard Ms. P. Bora, learned counsel for the respondent claimant. This interlocutory application has been filed under Order 41 Rule 5 of the Code of Civil Procedure 1908, praying for stay of execution of the impugned judgment and award dated 9/9/2024, passed in MAC within bracket death case number 3/2020 by the Motor Accident Claims Tribunal, Morigao. Notice to other two? Notice to 3 and 4?
By both registered and mutual process, Your Lordship.
Okay. The learned counsel for the applicant submits that the applicant insurance company is agreeable to deposit 25% of the awarded amount since the claimants are covered by compassionate pension scheme of the government of Assam. On this, the learned counsel for the claimant respondent submits that she has objection to the submission and prays for fixing this matter on some other day so that she can on some other day stop. The prayer is allowed. In the meanwhile, the applicant shall take steps for issuance of notice to other opposite parties by speed post as well as by usual mode within 7 days from the date of this order, returnable on 11 September.
Small, so we have not served with a copy of the permission provided.
Applicant shall furnish a copy of interlocutory application memo of appeal
Yes, sir.
not served.
We have already taken steps, Your Lordship, and they had filed a wakalatnama after that, but we have not received the so we should provide a copy maybe, sir.
Furnish a copy. I am not mentioning it in the
Not
record.
Obliged, Lordship.
Please, your lordship. This is a case where we got an army vehicle collided head-on collision with a DI truck, which is insured with the appellant. Now, my lord, we have been settled with the entire compensation of 1 crore 80 lakhs, my lord. My lord, but then there are materials to show, my lord, that the army vehicle was in fact in fault. It was on the wrong side. My lord, one is the PW2 in his evidence before, my lord, the London SDGM in the criminal proceeding, my lord. He deposed, my lord, that the army vehicle was on the wrong side, and my lord, the learned SDGM in the criminal case, my lord, found that, my lord, there is no rational negligent driving on part of the DI of the vehicle, DI truck, my lord, which is insured with us. And it was the army vehicle which was on the wrong side of the road, and it was driven in rational negligent manner, and it had created the accident, my lord.
You have
That judgment was placed before the tribunal, my lord.
Have you paid the compensation?
No, my lord, not been paid so. Because we are saying that this is a contributory negligence matter. Lordship will see my annexure, my lord.
Heard. Mr. M. Datta, the learned senior counsel assisted by Mr.
Elder.
L. Deka, the learned counsel for the appellant. Also heard Mr. D. Mandal, the learned counsel for the claimant respondents.
I am the caveated here.
Or claimants.
Claimant.
Slash caveator.
Number 1, 2, 3, na?
1, 2, 3.
1, 2, 3.
Slash respondent number 1, 2, 3. This appeal under Section 173 of the Motor Vehicles Act 1988 has been preferred by the appellant, Messrs. United India Insurance Company, against the judgment and award dated 1/4/2026, passed by the Motor Accident Claims Tribunal number 1, Kamrup Metro, Gauhati, in MSC case number 1966/2016, whereby the present appellant was directed to pay a compensation amount of rupees 1 crore 80 lakh 80,545 along with interest. I have gone through the grounds stated in the memo of appeal. This appeal is admitted. Let the records of MSC case number
1966.
1966/2016 be called for from the concerned tribunal registry to take steps for requisitioning the records. Let also notice be issued to the respondent. Since Mr. Mondal has appeared for respondent number 1, 2, and 3, no formal steps need to be taken for issuance of notice to the said respondents. However, as regards other respondents within bracket, respondent number 4 to 7, the appellant shall take steps for issuance of notice upon the said respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 11th September.
There is a stay petition also.
Stay
Subject to
deposit 50%. Heard and so. This interlocutory application under Order 41, Rule 5 of the Code of Civil Procedure has been filed by the applicant insurance company in connection with MAC number 374/2026, praying for stay of execution of the impugned judgment and order dated 1/4/2026, passed by the Motor Accident Claims Tribunal number 1, Kamrup Metro in MSC case number 1966/2016. The learned counsel for the learned senior counsel for the applicant submits that the applicant insurance company is agreeable to deposit 50% of the awarded amount as a condition for grant of stay of execution of the impugned judgment and award. The learned counsel for the respondent claimant has no objection to the same. Hence, notice to other respondents is hereby waived, and this interlocutory application is allowed. The execution of the impugned judgment and award dated 1/4/2026 passed in MSC case number 1966/2016 shall remain stayed during the pendency of the connected MAC appeal number 374/2026, subject to deposit of 50% of the awarded amount by the insurance company/applicant before the registry of this court within a period of 6 weeks from the date of this order. Stop. On such deposit, the said amount may be disbursed by the registry to the claimant/respondents after proper verification.
Well, subject to an undertaking because this is a huge amount. And
Huge. Even if it is huge, you are bound to pay 50% because that is your ground. Contributory negligence.
Contributory in the sense, how much will be the contribute? Because that was on the wrong side, totally on the wrong side. It was a vehicle which had hit my vehicle. And so therefore,
50%.
even if it's contributory, the contribution percentage may again.
How much?
That's the reason, they've been undertaking because
the case has been charge sheeted against their vehicle.
It was charge sheeted, but then finally
on that ground, their case, I think.
Because it is their money now.
Yes. No,
though you are challenging.
Charge sheet is one thing, but the court has come to a particular finding. Charge sheet goes. Charge sheet is only preliminary thing. The court has come to a finding that there is no rational
Is there any possibility that your liability will be less than 50%?
Quite possible, Miller, because the manner in which if the judgment is seen,
then submit a bond.
That's it.
Lordship, in this case, I think
Subject.
it's not necessary. But even if the
Subject to submission of a bond to the said amount, bond of the amount equivalent to the amount disbursed to them. list according.
Highly obliged.
Yeah, we have challenged the award for the learned MSCT to Kamrup Metro Lordship.
Heard Mr.
Here,
P.J. Burman, the learned counsel for the applicant. Also heard Mr. A. Agarwala, the learned counsel for the caveator. Caveat sobote discharge hobo. Jojot caveat ase. Learned counsel for the caveator / respondent claimant. Respondent number?
1 to 5.
1 to 5.
Respondent number 1 to 5 claimant. This appeal under section 173 of the Motor Vehicles Act has been preferred by the appellant, namely National Insurance Company Limited, impugning the judgment and award dated 24/3/2026, passed by the Motor Accident Claims Tribunal number 2, Kamrup Metro, in MAC case number 1926/2018, whereby the appellant was directed to pay a compensation amount of rupees 26,65,154, subject along with an interest at the rate of 9% per annum. I have gone through the grounds stated in the memo of appeal and have considered the submissions made by learned counsel for the appellant. The appeal is admitted. Let the records of MAC case number 1926/2018 be called for from the concerned tribunal. The registry to take steps for requisitioning the records. Let also notice be issued to the respondent.
No, Lordship, respondent 1 to 5, they were caveat, Lordship, they already got the copy, Lordship.
Only
Copy has been served.
Since,
1 to 5.
Since Mr. A. Agarwal has already appeared for respondent number 1 to 5, no formal steps required to be taken for issuance of notice on the said respondents. However, as regards respondent number 6, is concerned, the appellant shall take steps for issuance of notice upon the said respondent by speed post,
Lordship.
as well as by usual mode within 7 days from the date of this order, returnable 14th of September.
There is a stay application also, Lordship.
Subject to 50%.
Pay 50%.
Respondent claimant number 1 may be allowed to withdraw the amount, Lordship, without any right, because maximum amount has been spent on medical treatment, Lordship. She is the wife of the deceased, Lordship. And other 4 are the daughters, Lordship.
This application,
Parents' names.
this interlocutory application has been filed by the applicant insurance company in connection with MAC appeal number 393/2026, praying for stay of execution of the judgment and order dated 24/3/2026, passed by the Motor Accident Claims Tribunal number 2, Kamrup Metro, in MAC case number 1926/2018, whereby the applicant insurance company was directed to pay a compensation amount of rupees 26,65,154, along with an interest at the rate of 9% per annum. The applicant insurance company is agreeable to deposit 50% of the awarded amount as a condition for grant of stay of the impugned judgment and award. The learned counsel for the respondent number 1 to 5/claimant have no objection to the same. Stop considering the facts. The notice to respondent number 6 is waived, and this interlocutory application is allowed. The execution of the impugned judgment and award dated 24/3/2026, passed in MEC case number 1926/2018, is hereby stayed, subject to deposit of 50% of the awarded amount by the applicant insurance company before the registry of this court within a period of 6 weeks from the date of this order. On such deposit, the said amount may be disbursed
Respondent claimant number 1.
to the respondent claimant number 1 on behalf of all other claimants.
Without any fixed deposit or rider, Lordship.
Lordship, that
Because she is the wife and
That cannot
No
be-
such clarification.
Injury case and they have spent.
around 23 lakhs
Lordship,
on medical.
injury case, Lordship, inflated
No,
bill,
no
Lordship.
clarification. The
That is one of our ground, Lordship.
Kelly.
Disbursed to.
By the registry after proper verification.
Lordship. And Lordship, the notice to responsive waived, Lordship, waived. Because it's nothing to do.
Caveat
Uh,
discharge, Lordship.
Give it stand discharge. In main appeal, you have to take steps.
Lordship.
Notice only in this IA is waived. Please.
Obliged.
May it please your lordship, statutory appeal, lordship.
But Ms. R.D. Majumdar, learned counsel for the appellant. This appeal under section 173 of the Motor Vehicles Act 1988 has been preferred by the appellant insurance company, impugning the judgment and award dated 24/12/2024, passed by the Motor Accident Claims Tribunal number 2, Kamrup Metro, in MEC case number 2732/2018, whereby the appellant has been directed to pay a compensation amount of rupees 4,36,380.80, along with an interest at the rate of 9% per annum. I have gone through the grounds stated in the memo of appeal and have considered the submissions made by learned counsel for the appellant. This appeal is admitted. Let the records of MEC case number 2732/2018 be called for from the concerned tribunal. The registry shall take steps for requisitioning the records. Let also notice be issued to the respondents. The appellant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 14 September.
Though there is a stay petition, lordship, let them appear because this is a pay and recovery. Highly obliged.
May I plead your lordship? Your lordship, my claim has been dismissed.
Dr. D. Mondo, learned counsel for the appellant. This appeal under section 173 of the Motor Vehicles Act 1988 has been preferred by the appellant, whereby preferred by the appellant, impugning the judgment and order dated 24/3/2025, passed by the Motor Accident Claims Tribunal number 3, Kamrup Metro, Gauhati, in MEC case number 378/2021, whereby the claims application filed by the present appellant present appellants was dismissed. I have gone through the grounds stated in the memo of appeal and have considered the submissions made by learned counsel for the appellant. This appeal is admitted. Issue notice to the respondent. The appellant shall take steps for issuance of notice upon the respondent by speed post as well as the user book within 7 days, returnable 14 September.
LCR.
Call for the records of MSC case number 378/2021 from the concerned tribunal. The registry to take steps for requisition there.
Oblige, your lordship.
None has appeared for the appellant on call. Let this matter be listed in the next week on a date to be fixed by registry.
Item 54. Please, Lordship. Lordship, this appeal is prepared by the insurance company, Lordship, and there is a violation of the policy condition. At the time of accident, the driver of the vehicle was not holding an valid driving license, Lordship.
Heard Mr. A. Kakoti, learned counsel for the appellant. Also heard Mr. M. Talundar, learned counsel for the respondent.
Number 1.
Number 1/claimant. This appeal under section 173 of Motor Vehicles Act 1988 has been preferred by the appellant insurance company, impugning the judgment and order dated 10/3/2025 passed by the Motor Accident Claims Tribunal Kachar, Silchar in MSC case number 1021/2012. I have gone through the grounds. Issue notice. Date 14 September. Agonisna. 14 September.
Lordship, there is an I for stay, Lordship.
Lordship, subject to deposition of
the person.
person. And it
To
is the
Paribana, 50%. 50% deposit and release to the no.
One
Leak
payment
of
only.
money.
Number 1.
Heard Mr. A. Kakoti, learned counsel for the applicant. Also heard Mr. M. Talukdar, learned counsel for the opposite party number 1/claimant. This application under Order 41 Rule 5 of the Code of Civil Procedure 1908 has been filed by the applicant insurance company in connection with the MAC appeal number. What is the MAC appeal number?
MSC appeal number
263/2025, praying for stay of execution of the impugned judgment and award dated 10/3/2025, passed by the Motor Accident Claims Tribunal Kachar in MSC case number 1021/2012. The insurance company applicant is agreeable to deposit of 50% of the awarded amount as a condition for grant of stay of the execution of the impugned judgment and award. Stop. As such, the learned counsel for the claimant respondent has no objection to the same. Stop. As such, the notice to respondent number 2 and 3 is waived and this interlocutory application is allowed. The execution of the impugned judgment and award dated 10/3/2025 passed in MSC case number 1021/2012 by the Motor Accident Claims Tribunal Kachar is hereby stayed subject to deposit of 50% of the awarded amount by the applicant insurance company before the registry of this court within a period of 6 weeks from the date of this order. Stop. On such deposit, the said amount shall be disbursed to the claimant / respondent. Respondent number 1 by the registry after proper verification. This interlocutory application is accordingly disposed.
Obliged.